It's my understanding, before we get started, it's my understanding that Mr. Vogt is going to argue, but you're going to give a couple of minutes to Ms. Higgins?
Yes, Your Honor. The city clerk is sure she.
Okay, I can do that. Would you like to reserve any time for rebuttal?
5 minutes, Your Honor.
Okay. Whenever you're ready, you may get started.
Good morning, Your Honor. Public counsel. I represent the appellant, Twang LLC, in this matter. The issue to be decided in this case is whether the city of Cincinnati can simply tell its citizens, this is what we're going to do with your property, and there's nothing you can do about it. That is the definition of governmental overreach. That is the definition of the government acting in complete disregard of its citizens' constitutional rights. The city sent notices to my client that simply said the city was moving forward with the abatement of the unsafe, structurally deficient conditions of the building pursuant to Revised Code 715.26. And the city and the land bank were going to immediately stabilize the property and recover the costs. Twang was not afforded an opportunity for administrative appeal of the city's action. Twang was not given an opportunity to appear before any city representative or board to contest the action being taken, contest the action contemplated by the city. And I purposely use the word contemplated because at the time they sent the notice, they had no plans for the stabilization of the property. They simply decided, the city law department decided that they were going to take this action and not afford my client any ability to challenge it. The statute does say you have to give a notice, 30-day notice before taking that action. But for that notice to be effective, something has to occur in response to that notice, some opportunity. If there was no opportunity to contest the city's actions, why send the notice? Why give in the statute that says the government can give an opportunity to have the person enter into an agreement to do the work? Why have that if there's no opportunity or no obligation for the city to meet with the property owner to discuss what action they're going to take?
So your issue here was that the city said, the property was falling apart, right? I mean, everybody agrees.
We disagree that the property was falling apart.
That it was you disagree that it was even a danger or a problem.
Your Honor, be prepared, and this is what the court did and what the city relied upon. We had a report prepared, and I grant you the report did say the property is in imminent danger of collapse.
Okay.
But when the city was provided that report, the city took no action. The city did not barricade the building. The city did not take any steps to preserve the safety of the public regarding the building. The city simply, months later, sent the notice of what they were going to do.
Okay, but what your problem with it is that they said, we are going to take action to stabilize this building, but they hadn't received bids yet, and so you didn't know how much it was going to be costing? Is that what your real issue is?
Well, that's part of the issue is, again, the statute says you have to give this notice and give the property owner an opportunity to enter to do the work. They didn't specify specifically what work was to be done.
Right.
And they did not have any plans for the work to be done. That did not occur until months later, I believe in February of the following year, when they finally entered into a bid. But even the bid did not contain any contract, did not contain construction drawings, or the specific work that was going to be done. It was simply a bid that had been accepted by the land bank, the city's agent, to do the work. And we were never for that until right before the litigation began. And that's one of the issues we had, and we wanted an opportunity to say what this work is necessary for. And then the other issue,
because it was like $600,000, right?
Excuse me?
Was it $600,000 that we're talking?
We don't know what the bid amount was. $600,000.
Okay.
We have not seen what the actual cost was to complete the work.
Okay.
But the other problem is the statute talks about stabilizing the building. The rehabilitation contract with the land bank and the bid was to bring this building up to BBML standards, Banking Building Maintenance License standards. And that's not the same thing. There are certain things that are required to do to get a BBML that doesn't relate to structure and having the building be maintained in a safe and sufficient manner. So as we said, this court decided in 2008, City of Cincinnati versus George Masons, that when the city is proceeding under 715.26, the property owner has an opportunity, as They say, well, take a look at the statute. And the statute doesn't say, let's have a reconnaissance hearing. But we have a Constitution for a reason, and the Constitution is a limit on the power of government. And so a city, the legislature can't enact a law that disregards the city and the constitutional rights of parties. This is what I said earlier. It's a definition of governmental overreach, a complete disregard of citizens' rights.
Let me ask this, Mr. Fecker. When you had your expert report that said this building's in danger of collapse, what if anything, did your client do to alleviate the issue of the building collapsing and perhaps killing somebody on the street?
Well, that was the purpose of why we provided the report to the city, because there is a separate section that allows a demolition permit to be issued if the building is in a danger of collapse. So that was our request to the city. We believe, based upon this report, we should be able to demolish the building. In the city, we had after that report was provided, the city inspected the building, which was a complete fallacy. They took no tests, they took no reports, they just walked through the building. And so we did have our report that says these are the issues, but when the city was shown the report and inspected the building, they took no action. So they didn't contact us and say, well, you need to barricade the building. You need to put a barrier around the building. The building was barricaded, to prevent people from getting in and out of the building. But nobody took any step because we prevented this to the city, and the city didn't say, yes, these are real issues, and we need to address this. The city waited months until the legal department issued the notices of abatement. And there is a separate city ordinance that permits the building inspector to have a public issuing notice, have a public hearing, allow witnesses to be called, allow evidence to be presented. It's Code of Ordinance 1101.57.1. And the city did not proceed under that because they would then have to have a hearing by the rules. They used this statutory procedure, and I've never found any case that says, yes, if you rely upon that city or the state ordinance, state statute, you do not need to have a hearing. You do not need to give people.
Can you help me understand though? So you want to tear this building down. Correct. Ultimately, and you applied. You filed some sort of application with the city to ask.
We applied years prior for a certificate of appropriateness to the historic court, and the historic court denied that application.
Did you appeal? I mean, is there a way to appeal that, or?
We did not appeal that at that point in time, and I don't want to get into this because I don't think it's relevant. But this court, we had a prior appeal before this court, where the city had filed a prior action saying they wanted to appoint a receiver, they wanted to take certain steps. We then looked at the statute and says, well, under that statute, we can ask the court to give us a demolition order. And I respectfully still disagree with your decision, but you rejected my arguments.
Okay.
But we did. This building is economically not feasible in its current condition, even as stabilized. It was not economically feasible. And so we do believe that the building needs to be demolished to make this corner an economic return to the city of Cincinnati, rather than just keep it vacant for decades to come.
And that's for like aesthetic reasons that the city's keeping this vacant?
It is. The city of Cincinnati has a very unique historic district, where it's one half of a certain street for 2 blocks, and this building is on the corner, and it's within that historic district, and that limits how we can get what we can do with the building. But from our review and research, the building has no true historic significance. But again, that's not the issue. Is not focused on us. The issue is focused on what the city did and failed to do and failed to get us right. I would like to comment briefly on the motion to eliminate. We believe the court did err in that. We told the court we were going to name experts. The court did not give us any deadline. The court, by granting the motion, the court issued a scheduling order on the preliminary injunction hearing. Did not require that we name experts by a deadline.
What's our standard of review for that?
That is abuse of discretion. We do believe the court abused discretion again. The court knew what was going on and said, okay, Mr. Fecker, we need to name them by this date.
But she offered you a continuance, right?
She did offer continuance, but the temporary restraining order expired that Friday. The hearing was on Wednesday and Thursday. The TRO expired on Friday, and the city refused to extend the TRO. And so we
Okay.
The TRO would expire.
So you would have had no ability to extend the TRO if
Correct.
you took the continuance?
Correct.
Okay.
So, in conclusion, if you affirm the trial court for telling the city of Cincinnati that they can take any action they want without regard to citizens' rights, we would ask that this court reverse the trial court and remand for further proceedings.
Thank you. Whenever you're ready, Mr. Vogt.
Your Honors, opposing counsel, Walnut Hills, may it please the court. This case is about Twang's decision to try and demolish its own building through neglect because it simply and admittedly did not want to spend the money to get the property into code compliance. The city complied with the state law for repairing unsafe buildings to the letter. That's what the trial court found below, and that's what we ask this court to find today. The history of litigation surrounding 819L is long, and there are a few points I want to emphasize for this court, if you bear with me. This isn't the first time Twang has essentially tried to add words to a statute that don't exist. 3 years ago, this court rejected Twang's attempt to declare its building a public nuisance under Revised Code 3767.41, and this court also applied the waiver doctrine to Twang's challenge to the city's fines, finding, quote, that Twang simply ignored the city's repeated efforts to bring this property into code compliance until after the city filed its lawsuit. In the 3 years since, Your Honors, not much has changed regarding Twang's attitude towards its property. To your question, Judge Winkler, after the June 22nd, 2022 report that they had commissioned, they did nothing to protect the public. There's one more line from the record below I'd like this court to keep in mind as it analyzes Twang's claims. When the city's council asked Michael Story, the manager of Twang, about bringing the property into code compliance, Michael Story said, quote, that the cost of doing so would far exceed any economic recovery. So when the city attorney further clarified, so you're testifying that you chose to violate the law, Michael Story said yes. So that is who you are dealing with, Your Honors, an entity that chose to violate the law, and they did so because of money.
So is it my understanding that they are trying to allow this building to fall into such disrepair that the city will let them tear it down? Because that's what they want to do?
That's correct. This is a case of demolition by neglect. When Twang acquired this building in 2014, it's been in a historic district. It's been there since the 70s. They knew that this was in a historic district. This incidentally was the first Izzy's, if that matters to you guys. So they've been doing this for years, Your Honor. The city first issued a notice of violation ordering to keep this building vacant and bring it into structural compliance in 2016. The city cited them 8 times, and those 8 citations were the subject of Twang 1. They've had 8 years of actual notice of the unsafe nature of their building. So for Twang to come before this court and say they were surprised or they didn't have an opportunity to be heard is simply not credible. That issue is almost res judicata at this point.
But I thought their issue really is that the city said, okay, finally we're going to go ahead and we're gonna do this ourselves. And they said, hey, would you give us the plans and the estimates so that we can see what you're doing, so that we can determine whether or not maybe we should get a different bid or do, different action should be taken. And the city didn't give them the plans and the opportunity to see what you all were going to do.
So that goes to 715.26b. It does have a line in there that a property owner may enter into an agreement with this corporation or its landlord, its agent, in this case, the land bank. So may is permissive. Nothing says the city or the land bank has to do that. And additionally, the other important word there is agreement. It implies a meeting of the mind. So I don't think the city would have agreed that an entity that admittedly is trying to demolish their building, also at that time was in tax foreclosure, who was never satisfied with the $28,000 certificate of judgment that this court upheld in 21, was going to be a good candidate to repair its building in good faith. So they filed their action in this case for declaratory relief under Revised Code Section 715.26. It It's a simple statute that essentially has two parts. There's a substantive section that says a municipal corporation will repair unsafe and structurally defective buildings. And the procedural due process part is that prior to that repair, the municipal corporation has to provide notice of its intent to repair via certified mail. The trial court dismissed Twang's action. Declaratory relief, unlike other motions to dismiss, was reviewed for abuse of discretion. So there's no question in this case that the building was unsafe. Twang's own engineering report that had commissioned in June 2022 said just that. The time is now to protect the public. There was a huge hole in the section of one of the ground floors. The north face of the building was crumbling. It's in the record below that Michael Story said they had people sign waivers to enter the building. But in Twang's pleadings at trial, they said that the building was only possibly unsafe, but also that they're not saying the building is safe. I'd like this court to just pay attention to that vacillation. I think it's important because they know they can't admit that the building is unsafe because that's bad for them legally, but they know they can't tell you, you're not going to hear that it is safe because that's ridiculous. It's not credible. The procedural element, Your Honors, it's attached as an exhibit to Twang's complaint. The reply to the city's November 4th, 2022 certified mail to Twang appeared, quote, any possible deficiency with the notice provisions of that statute. So I don't know how they can, in good faith, stand before you today and say otherwise. So the trial court did not act unreasonably or unconscionably to dismiss Twang's case. We ask this court to affirm on that. If you do, you don't have to go to any of the other assignments of error. But as to the preliminary injunction, Twang failed to meet its burden by clear and convincing evidence for each of the four factors, naturally because the trial court dismissed their complaint and failed to demonstrate the likelihood of success on the merits, but also the trial court correctly found that there wasn't irreparable harm in this case.
Was there any alleged harm other than monetary?
No, Your Honor. They tried to talk a little bit about legacy. You see that in their brief. But in the record below, Michael Story said the city's stabilization, when he asked how it would harm Twang, he said it would be a financial hardship. He said they would lose all the money that they spent. Economic loss isn't irreparable. You can repair it with money. So the stabilization of 819 Elm also, ironically, it didn't harm Twang, it helped them. Heidi Clues said at trial that the building was worth $622,000, more than double its assessed value, coincidentally the same exact amount that the city spent stabilizing its property. So this is really, I think, a unique case in that you have a city repairing a building that an owner is demolishing by neglect, and the owner's before you telling you that the city is the one harming the property. It's the exact opposite. Judge Krause, as to the last assignment of error, you did correctly point out or ask Mr. Fecker. The trial court asked Mr. Fecker if they would like a continuance to get expert testimony. They declined that offer, even if it meant losing the TRO. Because they declined that offer, that issue was waived. But additionally, the trial court correctly excluded expert witnesses that hadn't even authored the report, that hadn't been inside the building, just 2 days before the city's the hearing on Twang's preliminary injunction. Your
But the
Honors,
city, just to be clear, the city refused to extend the TRO, right?
that's correct.
Okay, so they were in a tough spot on determining whether they would ask for a continuance or not.
I think that's fair, Your Honor. They were in a tough spot, but the rules of waiver still apply. But if this court declines to rule in that fashion, the trial court didn't behave unconscionably or unreasonably when it excluded those experts. They hadn't even been inside the building. One of the rules of civil procedure is to, for the purposes of the rules, is to prevent against unfair surprise. Excluding experts because of surprise is viewed under discretion. The trial court was right to exclude those experts in this case. So, all of these decisions, I keep saying, were made at the discretion of the trial court. An abuse of discretion is more than mere error. It implies that the trial court acted unreasonably, unconscionably, or arbitrarily in its decisions. I don't think that the trial court acted unconscionably when it dismissed the lawsuit of an entity and said on the record that it was choosing to violate the laws for building safety because of money. There's no dispute that the city complied with revised code section 715.26 to the absolute letter. We ask this court to affirm the judgment.
So how would you respond to your opposing counsel's argument that, yeah, that's what the statute says. It only says notice, it doesn't say opportunity to be heard, but the purpose of the Constitution is to ensure that people do have both notice and an opportunity to be heard, and the Constitution limits government power.
There's no doubt that the Constitution limits government power. Judge Bach, they didn't plead a constitutional challenge to this case.
Well, let's say that we can infer that notice pleading state that they did. So if we were to say, okay, this notice pleading state that we have, this was enough.
So I think, honestly, Your Honor, for this court to infer that, you'd have to apply plain error to this case, and this court has repeatedly held that it doesn't. Sua sponte apply plain error, so I'd ask this court not to deviate from that. Twang didn't put the city on notice of any due process violations when it filed declaratory relief specifically under revised code 715.26. That's what this statute, that's what this case is about. The city complied with that statute. They've waived any challenge either as applied or facially to the application of 715.26, which just wasn't in the brief. And they explicitly, on the contrary, they explicitly say in the brief that they're not challenging that statute as applied.
Thank you.
Thank you.
Good morning, Your Honors. My name is Amy Higgins. I'm representing the County Land Revitalization Corporation, also known as the Land Bank. We are in this case today.
Can you speak up just a little bit, please? Thank you.
We are in this case today as an agent of the city. We've talked a lot about revised code 715.26 and 0.261. Those statutes allow the city to delegate the stabilization procedures to a county land revitalization corporation, also known as a land bank. So I'd like to start use my brief time to respond first to Judge Krause's question on the plans. This is a somewhat disingenuous complaint and somewhat of a red herring. We did discuss it at trial. That's because the VBML standards are a matter of city statute. Twang has known for years exactly what code violations they have and exactly what they need to do to cure those code violations. Inasmuch as there may not be exact blueprints and this needs to be replaced and that brick needs to be tuck pointed, again, that's a fundamental misunderstanding of how stabilizations work, and I would contend that intentional misrepresentation of not wanting to understand how stabilization works, since that's not the goal of Twang here, but a demolition. You get a bid, the bid is an estimate, they don't have x-ray vision, they can't come in and see which beams and which bricks behind the plaster need to be repaired. That can only be accomplished once the work starts. And again, that was something they had years to achieve on their own. They made strides in that area, for example, commissioning the HON report that says the building is a danger. And they very well could have had those same estimates and bids drawn up themselves, but chose not to. Also disingenuous is their claim that there's no opportunity to be heard. Judge Bach, to your question, this is their opportunity to be heard in front of an audience, no less. They had 4 or 5 months between when the notices were first sent under 715.26 and 261 in October and November. They actually sent notices just to do the belts and suspenders approach, and they had every opportunity during those months to bring their claim, but they waited until March 31st. So to the issue of not getting any more extensions from the city on the TRO, again, 4 or 5 months in which they could have gotten that expert report rather than sandbagging counsel on the eve of trial. So a lot of the reason why we're here, I would say the entire reason why are choices that Twang made over years and years and years, and choices that they opted to forego, like getting their own bids, like getting their own experts, like buying a building in a historic district that they knew or should have known can't be demolished. And because of that, the trial court made the decision that it did, and may I see you with that decision?
Thank you. You have about 5 minutes remaining.
Points to make. This issue is not about Twang's decision to try to demolish the building. This is about the city's overreach in imposing their will and their decision upon a property owner without affording due process rights. The city's added language to the Constitution that says you only get due process rights if you're not a bad person. This court is well aware criminals have due process rights, and yet they refuse to afford us our due process rights. I believe Judge Krause indicated, merely sending a notice is not due process rights. The city can't say under our Constitution, this is what we're going to do, and there's nothing you can do about it.
But how do you respond to this last argument that your client was told precisely what needed to be done with that building to stabilize it, and then your client could have gotten bids themselves?
We were not told that. Again, we were not told that. The prior notices that they referred to, we satisfied every requirement of those notices but one, which was to get a VBML license. To get a VBML license, you have to satisfy 13 different points. And economically, getting those 13 points satisfied would have rendered the building the same level of usability, which is 0. So we did not ignore the city's notices. We addressed the issues, we barricaded the building, we kept it vacant, and we addressed these different issues. But this building, in its current condition, is simply not economically feasible. So in this time period, since we got the notice, we repeatedly asked to meet with people to discuss what the plans were. And we weren't provided the plans. We only had correspondence with the city's attorneys, never the building department. And so,
Was the intention of what the city was doing, I thought they were just trying to stabilize the building, not make it economically usable.
they were trying to stabilize the building, but they've taken a building that is economically unfeasible in its current condition, spending $600,000 at least, which was the estimate, and you still have a building that has no economic value. This argument that the building increased value by this work, that is part of the abuse of discretion of the trial court. There was no evidence that as a result of spending this money, the value would increase. The court statement in the decision that we're irreparably benefited by this money is a fiction that she made up in her own mind. It's a predetermined result that she had, because she was focused on the historic nature of the building and the fact that our goal was to demolish the building, rather than taking a look at the city and saying, you gave them a notice that was completely meaningless.
Tell me what else, so just so that we understand precisely what was lacking with this due process. What was lacking here? What did you need?
We wanted to have a meeting and a hearing to present our testimony as to perhaps we didn't need to do this work to stabilize the building. This contractor could have done it at a different cost, or that this work was simply not necessary, but we had none of those details. We only had one bid from Kiker. That was really that bid, and that bid was also open-ended.
Couldn't you have gotten your own bid, though?
We were trying, and that's the point. We were trying to work with the city to accomplish those goals, and yet we weren't told that on March 23rd the work was going to begin. On March 23rd, we went to the property, and Kiker had changed the locks on our building and installed their own locks. We had no prior knowledge that was a thing that was going to occur. We were still discussing with the city and expecting information back from the city, and the city was not being responsive. They were engaged in a secret plan to take over our building without giving us an opportunity.
But what you're saying under this particular statute is that that the building owner should be given the opportunity to see the city's plans and then to go get their own plans and to decide if they're going to go with their own plans? Is that what you're saying?
Or to appear before somebody with the city who's made the decision, this is the work that's going to be done, and to contest the necessity of that work, the cost of that work, or the benefit of that work. Opportunity to be heard is an important component of due process. It's simply saying, here's your piece of mail, we're going to close our hands, we're going to close our eyes, cover our ears and not talk to you for the next 30 days is the definition of governmental overreach. This concept that they were unaware that we were going to raise these issues is contrary to what the trial court said in its entry decision granting defendant's motion to dismiss. We had communicated with the city in January of 2023 that their actions were improper, and as the court said it, at the same time it granted the motion to dismiss, the client communicated with the city, arguing the city's actions were improper both under statute and the Constitution. The same day we filed our complaint, we filed a motion for injunction where we laid out all the due process violations. And so the argument that they were surprised by all this, in my opinion, is a stretch. Again, reverse the trial court so the cities know what they can and cannot do, what overreach they're permitted to do, which should be zero. It's about property owners' the rights to interact with the city and not just count out whatever they do.
Thank you. That concludes our arguments for today.